Wherever you are in the world, can you all see and hear me? Give me a 5x5 in the chat. Tell me that you can see me on YouTube, otherwise known as SpewTube, because it's a propaganda arm of the deep state. Let's have a look and see what else is coming out there. And you can see me on Locals, you can see me on X, and you can see me on Rumble, our most favoured platform, because it is a free speech platform. So give me a 5x5. Can you all see and hear me? Treason law must be put into action urgently. No more UK taxpayers' money paying into treason. End of. Taffy Pat, I absolutely agree with you. Andy, 937AD, 5x5 on Rumble. Well done. Before I get into the actual show, did anyone see Robin Tilbrook on UK Column today and see how Brian Gerrish seems to be completely changing his tune with the English Constitution and now finally admitting England does exist? I did watch it today. I can tell you I was extremely polite when I was watching it. I mean, he kept saying about that certain people were more, what was the word he used? What was the word he used? Not tough. It was
harsh.
Harsh. Some people have been quite harsh with him in the past. I think he was making references to people calling him a effing traitor. Of course, I wouldn't know who he was talking about. But if there's anyone that watches UK Column, I see today that there's plenty of people in his chat saying, you need to speak to Graham Moore. You need to speak to Graham Moore. And then he was saying, yeah, well, we used to have this event and used to talk about the English Constitution. And at one stage, we got 500 people there at an event. Really? Anyway, it's not for me to say any more than that. Only to say I absolutely agree. The people who committed treason, and in particular, I'll tell you what I'll do to Andy Burnham. Constitutionally, when England takes back England, and one of the first things you have to do is to pull the British Nationality Act 1948, right? Second thing you have to do is abolish any changes to our. So we go through. There's at least 50 laws that have been either repealed, slightly repealed, abolished, a lot of them, and then what we immediately, right? So you put the English Constitution into full force. You'd then be able to sack the judges. A lot of the judges that are foreign, that means not of English parents, plural, and all these other people, you get them out of positions. You then, again, the English Constitution, Halsbury's Laws of England, you would purge the civil service and other elements, including elements to do with the security of the state of fascists and communists. And then what you would do, you'd put someone like Andy Burnham and other Fabians on trial for subverting the English Constitution. You would have a jury trial by due process. They would be given a fair trial. The evidence will be placed before the jury, all English, and we will explain the situation. If they are found guilty of subverting the English Constitution, which I firmly believe they would, with the right person presenting the case, they should be hanged. If found guilty, should be hanged, drawn, and quartered. And I am unashamed to say I will volunteer to either prosecute, with that being the punishment if they get found guilty, and if I couldn't do that, I would 100% volunteer to do the hanging and the drawing and the quartering, right? And no, I'm not kidding about that. I believe it needs to be done publicly, right? That's how heinous what's going on towards England today is, and certain other people that have betrayed us and betrayed our nation, that have collaborated with the enemy, including on YouTube, including events, referencing no such thing as England or the English Constitution. I think they should be very careful, and I don't give a flying fig how old they are. Treason is treason, and what they've tried to do to our country and what they are currently doing to our country is terrible. So that said, please share, because sharing is caring. Share as much as you can. Don't forget to subscribe. If you're on YouTube, come across onto Rumble, come over, find us, the Full English Show. Hit the subscribe button. There's a little process you go through. Just click another button and it gives you when we're live, etc. We're gradually ticking over. We want to go over 10,000 subscribers on Rumble. It is the platform to be on. It's the only platform that allows you to have proper discussions. If there's anyone that you want to come on the show, right, then let me know. If I've got an email, I'll ping them an email and they can come on and we'll have a chat, right? If there's any of you that want to come on, don't talk about your own personal problems and cases, because there's probably things that you don't want to be saying live on air if you've got a case going. But I've not got a problem with speaking to people. Stevens Norman, there's plenty of bent judges out there. And we need to go back to the old-fashioned way of doing things with the judges. That means hang them, right? That means take all their worldly goods, all their chattels. That means make them destitute. If they haven't done bad enough to be hanged, and I know a number of that have, especially in the family courts, I'm telling you now, they need to lose everything and stick them on a boat and tell them Foxtrot Oscar. But people need to know, and the reason why I like Rupert Lowe is actually saying it. These people are parasites. And I absolutely agree. They have been, most of them have been wrongly instructed on the English Constitution. I think it's disgraceful. It's disgusting. Like I said, I would shut down Oxford University. And anyone that's got any degree from that university, I would pull all certification, all degrees and everything, and say you've got nothing, right? Because that is the centre of the mind virus. That is the communist institution that's been propagating this. If you look at 78% of our prime ministers have come from, since the Second World War, have come from that university. Let me tell you something. That place is dangerous and needs to be shut down. And it is collective punishment. Good. If you've been at Oxford University, I'm telling you now, I would campaign all day long to shut that gaff down completely. Pull every single degree it ever put out and say you need to be shut down completely for what you've done to England. I think I've made myself clear on that. What we're going to do now is I'm going to take you over. Now, you've been... A lot of people are very angry at the moment about, and there's I think on the 3rd of July, I can't remember the exact date, there's a demonstration outside. I'll see if I can bring it up on your screen, but if I don't bring it up on the screen properly, it might go pear-shaped on me. Let me see if I can bring it up, because I think it's important. First of all, it shouldn't be a demonstration, it should be a legitimate petition to the Crown, right? It's a very powerful thing to use our petitioning rights to the Crown. The police can't tell you at the Foxtrot Oscar. They can't tell you to stand in a certain place. They can't. You have an absolute right to petition the Monarch, English Bill of Rights, and the Petition of Right. Right. So what I'm going to do now is show you something I think that has come up. I'm not sure if I can bring it up on your screen or not. I think I can. And this person is Chris Wickland. But again, I wish he had took advice from me, and I would tell him, if you want to do this, you must do it as a petition, right? And don't forget, I've got personal experience of that. Protesting against King Charles, it's the actual monarch, promoting Islam whilst neglecting persecuted Christians, his dishonour and lack of defence of the faith, his lack of honour, and to Christ, we will be calling King Charles to account for his decisions. 4 o'clock Friday, 3rd of July, Windsor Castle. There it is, right? So I've just put a shout out on there for this particular person, but he needs to change this to a petition. It's not difficult to do. and I'm just making sure that everyone understands that. What I'm going to try and do now is bring something else up on it. Right. So now I'm going to have a discussion about England and Christianity. I'm hoping you're going to be able to see this because I can't actually make it any bigger. So hopefully you can see this on the screen, right? This was November 2013. It is Augusta Zimmerman, A Law Above the Law, Christian Roots of the English Common Law. Can you all see that? So the abstract of this, what it's actually about, the English common law has an incredibly rich Christian heritage. England's most celebrated jurists, including the likes of Blackstone, Coke, Fortescue, often drew heavily from their Christian faith when expounding and developing what are now well-established principles and doctrines of the common law. This article demonstrates how Christian values and principles underpin the English common law and how they still remain valid to the interpretation of the common law even to the present day. Finally, the article explains why Christianity has always been an important element of the common law and why the Christian foundations of the common law should not be ignored or neglected, right? And then it goes in, he's got a PhD, LLB, LMM. He's a lecturer, teaches at Western Australia's Murdoch University School of Law, where he's currently a senior lecturer in law. So this fella knows what he's talking about, right? I've had this document years. Now, before I go into the detail, I want to pop down and show you a couple of quick highlights. There's one in particular that I want to make sure everyone understands what is actually said. And I'm hoping that I have took that part out and I think I've got it in there. Let me have a look and see where it is. I'm sure I actually put it in a document, but there's a particular bit that I want to show you. It's always the way I can never find it when I'm cracking on. So are you happy for me to do a readout of this because it's crucially important and it certainly ties into the event at Windsor Castle? I've been there and protested in the past, or petitioned in the past I should say, and I just need everyone to if you want me to read this out. It's fascinating, it's real law. There's some other elements of this that I'm going to talk to you about when I get to it. I'm going to go to another web page and show you what the case was actually about. I've actually got the full transcript of the case in the 1600s where this was spoken about, and someone went went up in front of a number of judges for treason, and he was talking about the English common law, etc. His name was John Lilburn. They used to call him Freedom John. And he was one of us, and there was a number of different people. So this should be interesting. Again, I've got the PDF of this document. A Law Above the Law, Christian Roots of the English Common Law. Introduction. Common law means a legal system based upon the English legal system, a mixture of customary law, judge-made law, and parliamentary law. And we haven't got destitute, remember. So common law is the opposite to Roman law. Scotland has got Roman law, has not got a common law jurisdiction. Parliamentary law. At least until the early 19th century, the common law was heavily influenced by Christian philosophy. This philosophy argues that there is a divine reason for the existence of fundamental laws and that such laws are superior to human-made legislation, thus reflecting universal and unchangeable principles by which everyone should live. This assumption was expressed, among other things, in the Magna Carta 1215 and obviously prior to that, the Charter of Liberties, a charter which guaranteed the basic rights and privileges of the English barons against the king. Professor Aroni explains Christianity's ideological influence upon the Magna Carta. From the time of Alfred, the kings of England have traditionally recognized their submission to God. At their coronations, they take an oath before the Archbishop, acknowledging the law of God as the standard of justice and the rights of the Church. They are also urged to do justice under God and to govern God's people fairly. Magna Carta was a development of these themes, right? So at the bottom of this, it then tells you exactly where you go and find it. That's the Society of Australia. Presbyterianism. There's loads of different things, and on the footnotes it tells you everything that you want to go and have a look at. As can be seen, Christian philosophy has been central to the origins and development of common law since its conception. In the early stages of its development, and at least until the early 19th century, the common law rested almost entirely upon religious conception that looked to higher or natural law as the primary basis for judicial decisions. In those days, Christianity formed an integral part of the theory of English law and civil government. As the late John Wu pointed out, while the Roman law was a deathbed to convert to Christianity, the common law was a cradle Christian. Stephen C. Perks explains that in his influence was a necessary result of English society. The emergence of the English common law system occurred in an age and in a culture steeped in Christian theology, Christian morals, and a Christian understanding of the meaning and value of life. The influence of the Christian world view was determinative for social institutions as well as individual lives. In this sense, Sir William Holdsworth merely explained the traditional view of the close relationship between Christianity and English law when he declared Christianity is part and parcel of the common law of England and therefore is to be protected by it. Now, whatever strikes at the very root of Christianity tends manifestly to dissolution of civil government. Holdsworth did not make his terminology up out of thin air. In a 1649 case, for instance, an English court had declared that the law of England is the law of God and the law of God is the law of England. Right. In a 1676 case, Sir Matthew Howe, I've got his books here, stated Christianity is part and parcel of the laws of England. Now, before I go any further, Holdsworth did not make his terminology up out of thin air. In 1649 case, for instance, English count, and then it goes on. What I'm actually going to do now is show you where that come from and who it was. So this is the guy, and again, I'm going to go back to the actual readout. This is the guy whose case it was. John Lilburn, 1614 to 29th of August, 1657, also known as Freeborn John, was an English political leveller before, during, and after the English Civil Wars. Now, he actually fought in the Civil War alongside Cromwell, but Cromwell and him didn't actually get on, but they fought together, right? And there's a number of situations that happened with him, but he actually got put on trial. And what I'm going to do is take you to his trial, right? So again, I'm going to go to this element, so hopefully we will see it. Now, this is, hopefully, let me see if I can actually cut that across. If anyone wants to go and read the transcript of the trial, right? So this is the type of thing that you would take in if you was doing a massive course at the moment. Sorry, let me just make sure I'm sharing this. Share this tab instead. I wasn't sharing it. This is the actual trial itself, right? So let me go back up to the top, and you'll see what I'm talking about. And then I'll go back down the bottom. I know I'm going to whiz through this. If it makes you feel sick, I do apologise. Library digital collections, early English books online. The trial of Lieutenant Colonel John Lilburn by an extraordinary or special commission and then it goes into, but this is the actual record of that trial, and it's been digitized so anyone can see it, right? So let's go to point 1 on this. This is one of the judges talking to Mr. Lilburn. Pray spare me a word, for you have been heard with patience. You have desired to have the right of law or right of the law of England, and yet you do question a fundamental thing that have been always used in case of criminal offences by the law of England, that you desire to have the meaning of it. Is but just you must know that the law of England is the law of God, and if there be anything in the law of England but what was by admirable constitution and reason, we would not meddle with it. But I pray know this, that the law of England is no written law. It is the law that hath been maintained by our ancestors, by the tried rules of reason and the prime laws of nature. For it does not depend upon statutes or written and declared words or lines, and this is our laws that have been maintained by our ancestors and is subordinate to the law. The will of God, therefore, I say again, the laws of England is pure, primitive reason, uncorrupted and unpolluted by human humours or humane corruptions, wits or wills, that the laws of England, there be 2 reasons why holding up the hand has been used always. First, for notice that those that are called for capital and criminal offences, that they hold up their hands is to declare that they are the men. My Lord hath given you this one reason already, which I say had to be notified by holding up the hand to all of the beholders and those that be present and hear him, that he is the man. But besides this, there is more in that. That's thus a pure, innocent hand, thus set forth a clear, unspotted heart, that so the heart and hand put together might betoken innocency. And therefore hold up your hand, that thereby you may declare you have pure, innocent heart. If you refuse to do this, you will willfully deprive yourself of the benefit of one of the main proceedings and customs of the laws of England. Now, for this, do what you think fit. Right, so the judge is basically having a go at him in the trial. Again, you've got to read through the whole. This is a real transcript, by the way. So again, another judge, Keeble, and that which you said, Mr. Attorney, have had so much time against you, an opportunity to consult with all manner of counsel to destroy you, your secret actions, though they are now come to public view, are so heinous as they do require time to put them into most sure way of trial. We have proved the clandestinities of these. You did this in secret. Now it has come to face of the world. Now this being matter of fact, no matter of law, can appear till proof pass upon it. You have had times to complot your treasonable, venomous books, which shall be proved upon you. Until this be done, there is no matter of law to be looked at. This is the law of God. When a man hath done such a treasonable things, he shall answer directly and positively, whether he be guilty of them or no. And if he answer not guilty, and they be not fully proved against him, there needs no more to be said. Right, and it goes in without me going through the whole of this. That all I'm doing is showing you from this document. They make a reference in law to this case. This case of the full verbatim transcript has been put into digital form. Again, in the past, I've gone back and read whole trials on the Constitution and subverting the Constitution, Cato conspiracy, for example, 1820. it's literally at the Old Bailey. You can go and read all through it, and the whole trial is in there. And by the way, they played the race card then as well. So what I'm doing is going back to this document. So I'm going back to this again now. So what I've just explained to you and showed you on the screen, hopefully I put on there what that link was. So if anyone wants to see that link, they can. Hopefully you can get to it via that link, and we'll put it on there, right? So again, we're going to carry on with the actual readout. In 1676 case, Sir Matthew Howe stated, Christianity is parcel of the laws of England. Chief Justice Raymond paraphrased Howe in his statement that Christianity in general is parcel of the common law of England. Sir William Blackstone matter-of-factly remarked that the Christian religion is a part of the law of the land. Lord Howe's statement, therefore, achieved an almost axiomatic status and retained this status throughout the 19th century, so that Holdsworth could state that the maxim would, from the earliest times, have been accepted as almost self-evident by English lawyers. Right. So what is the problem we've got today? So with that, I'm jumping off of the readout, looking at you directly, right? Part of the problem is the Fabian Society. There's another group of people called the Secular Society. In 1915, they brought a case, Bowman versus the Secular Society in 2015, where they challenged earlier rulings of the 1860s, the 1820s, and it went right back to the 1700s. The problem was the Fabians had infiltrated our judiciary. We had Jews that were judges, right? So they were not Christian. And in that particular case, they struck out any reference to England, to the common law being Christian, right? Now, I can tell you now, if you go back through the history, that was a corrupt judgment, and restore Britain, to restore England to the common law and God's law of England, they need to get that struck out. They need to reset that and say that was a corrupt judgment. It was put in place by the Fabian Society and the Secular Society, and England needs to go back to being a non-secular Christian nation. Full stop. No Jews, no Muslims, no Sikhs, right? What I mean by that is you cannot have positions of authority. You cannot be members of parliament. You cannot be in the House of Lords. And you cannot conduct any business in this country of England if you are of a foreign religion, right? That's what's caused this problem. Now, what I'm reading out to you are facts, and this is a factual document written by someone who is a professor of law in Australia. Right? So Sir Henry de Bracton, 1210 to 1268. Among the English jurists who were instrumental in the development and refinement of the common law was Sir Henry Bracton. His exceptional contributions even earned him the deserving title of the father of the common law. In Bracton's De Legislatis Constitutionis Angli, Latin, one finds the very first systematic treatment of the common law. Nowadays, the term jurisprudence is commonly defined as the science of law. However, initially, the actual meaning of the term is far richer and more encompassing than such a vague generalization. Thus, in Bracton's book, jurisprudence is rather described as the science of the just and the unjust, whilst the proper application of the law is declared to comprise a just sanction, ordering virtue and prohibiting its opposite. His most celebrated statement, of course, is that the English monarch ought to be under God and the law. The king himself, Bracton famously declared, ought not to be under man, but under God and under the law, because the law makes the king. For there is no king where will and not law wields dominion. That as a vicar of God, the king ought to be under the law is clearly shown by example of Jesus Christ. For although there lay open to God for the salvation of the human race many ways and means. He used not the force of his power, but the counsel of his justice. Thus he was willing to be under the law, that he might redeem those who were under the law. For he was unwilling to use power, but judgment. These are probably the most famous and important words ever pronounced in the whole history of the common law. As Pluckett put it, here was an antidote to that state absolutism which the later Tudors, Welsh, and the Stuarts, Scottish, attempted. Such words of Bracton were famously evoked by Sir Edward Coke during the celebrated dispute with King James over the superiority of the common law. In the 17th century, King James asserted that, as the sovereign monarch, he personified the law. Coke dared to disagree, thus reminding the king that, as Bracton has once observed, the king shall be under God and the law, for the law makes him king. In reflecting upon his remarkable fact in English legal history, Lord Denning, the most celebrated English judge of the 20th century, commented, "Those words of Bracton quoted by Coke, the king is under no man, save under God and the law, epitomise in one sentence the great contribution made by the common lawyers to the Constitution of England. They, the common lawyers, insisted that the executive power in the law under the law, in insisting upon this, they were really insisting on the Christian principles of the common law. If we forget these principles, where shall we finish? You have only to look at the totalitarian systems of government to see what happens. The society is primary, not the person. The citizen exists for the state, not the state for the citizen. The rulers are not under God and the law. They are a law unto themselves. All law, all courts are simply part of the state machine. The freedom of the individual as we know it no longer exists. It is against that terrible despotism, the overwhelming domination of human life, that Christianity has protected with all of the energy at its command." Remember, Lord Denning done the first lecture, Freedom Under the Law, for the Hamlin Lectures, which is a free resource for anyone to go and pick up off the internet, Exeter University, right? Sir John Fortescue, 1394 to 1476. The sentiments of Bracton concerning the nature of laws were embraced in the following century by Sir John Fortescue, who was the Chancellor to the King Henry VI and Chief Justice of the King's Bench, deeply recommended for his great wisdom, gravity and uprightness. In his book, De Laudibus Legum Angli, Fortescue declares that the laws of nature sprang from God alone, is subject to the law, his law alone, and under him and with him governs the whole world, whence it comes that all other laws are its servants, including the Roman law, right? So any other law is the servant of the common law, which is one of the reasons why Islam, Judaism, Sikhism, anywhere that adopts a legal system as part of its religion hates Christianity, hates the common law, and above all, hates England, right? The law never above the law. The king would have no power to change the basic laws of the realm at pleasure. What is more, Fortescue further explains how God would have instilled in every human being a natural sense of liberty, so that tyranny is described by him as the attempt on the part of civil authorities to replace natural freedom by a condition of servitude that only satisfies the interests of oppressive rulers. Romans, biggest slavers anywhere, anytime in the world. The Romans were the largest slavers anywhere, right? For law, Fortescue concluded, is necessarily a judge cruel if it increases servitude and dismisses freedom, for which human nature always craves. For servitude was introduced by men for vicious purposes, but freedom was installed into human nature by God. Hence, freedom taken away from men always desires to return, as is always the case when natural liberty is denied. So he who does not favour liberty is to be deemed impious and cruel. Why is that such an important statement? Because them words was also used by Granville Sharp in Stuart versus Somerset, 1772, right? Those words and other words which was explaining that under Christian laws, under Christianity, you cannot be a slave. And that a slave cannot be a slave in England, right? And that case was the case that brought down slavery worldwide. That was the start, right? And it started well before that in late 1600s, early 1700s, with again Sir John Holt, the Chief Justice, who ruled in another case that as soon as a Negro's feet touch English soil, that Negro is no longer a slave, right? So people need to understand it's us, the English. We are the people. We are the people that saved the slaves. We are the ones who pulled them out of slavery, right? And this is what's happening to us now because of the Marxists, because of the Jews, because of the Jesuits, the Roman Catholics who hate us. Why do they hate us? Because all they want to do is enslave people. And the English have never been up for that. We've always said that's not the way we do it here, right? So making sure you understand what that is. Christopher St. Germain, 1460 to 1541. Following the Reformation tradition in England, the jurist Christopher St. Germain played a substantial role in the development of equity practice by the English lawyers. St. Germain conceived the first systematic attempt to establish a doctrine of precedent that would define how the chancellors ought to decide a given suit. In his seminal treatise, Doctor and Student, 1523, St. Germain undertakes a rather detailed analysis of the relationship between law and conscience, which makes no appeal to the secular science. The whole dialogue is premised on true religion as the foundation of understanding law and equity. Conscience is hereby understood in terms of the natural ability of individuals to be open to the call of truth that is objective, universal, and the same for all who can and must seek it. It is in this relationship with common and objective truth that conscience finds its dignity. There are three types of law according to St. Germain. The will of the Creator as made known by the law of nature or reason. The written law of God and the law of man. The law of reason is the portion of the eternal law which is known by all humans through natural understanding. The written law of God, by contrast, St. Germain defines as the revealed law derived from the Bible and the ordaining the human soul to salvation. Like Aristotle, he contended that the law of man is based on the necessity of peace as well as on the need of coordination in society. In other words, we need laws. And yet, he informed that any law which is contrary to the law of God is not righteous or obligatory. Curiously, St. Germain believed it to be rather inconceivable that the English Parliament would ever dare to legislate against the laws of God. Just let me stop that for 1 second, right? Bearing in mind our Parliament have just passed laws on abortion, almost full term, right? Bearing in mind what our Parliament is currently doing. Bearing in mind what the Labour Party and the Conservative Party and Reform have been doing, right? Just look at what the courts have been doing, look at what Parliament's been doing, and then look at what this crown, this monarch, is currently doing. And you've got some people out there on YouTube, not going to say who, but some American Scot who believes that the king has been captured. The only person who's captured this king is the devil himself. As he explained, it is not to presume that so noble principle and their council, nor the lords and the nobles of the realm, nor yet the commons gathered in the said parliament, would from time to time run into a great offence of conscience, as it is breaking of the law of God. In some, St. Germain believed in the wisdom and ability of the Parliament, which represented the collective wisdom of the entire realm and the Church of England, right, which has been infiltrated at every level. The Church of England has been infiltrated, right? But wisdom and entire realm of the Church of England to both accept and recognise the supremacy of God, laws above human law, including laws enacted by the English Parliament. Richard Hooker, 1554 to 1600, another key figure in the development of common law. The Anglican theologian Richard Hooker set the stage for the debates and raged in the 17th century about the nature, sources and purposes of the English law. John Locke drew heavily on Hooker's jurisprudence when he developed his arguments in second treatise in the 1680s, which I've got on this shelf. According to Hooker, true law invariably rests on three basic ideas: reason, morality, and the natural sociability of human beings. Although he believed that crimes such as murder, rape, and theft were eternal violations of the natural law, Hooker, notwithstanding, reminded that the particular type of punishment to be applied for each of these crimes of an universal nature must be the understanding that society is always bound by certain principles of natural law, that they are both eternal and inviolable, although its subsidiary laws may vary according to the needs of particular times and places. A subsidiary law is the laws of Devon, as the county of Devon, the shire of Devon. A subsidiary law that Norfolk makes for its own people is a subsidiary law. That's why we had a distributed legal system that operated to the shire, to the district councils, to the county council, and to the parishes. So the people govern themselves naturally at their own level, right? But they were never allowed to go against the Constitution or the common law of England. If they did that, they got brought, the case could be brought within the Royal Courts of Justice, and the separation of powers would kick in, right? Where the judiciary would strike it down. But the judiciary can also strike down primary acts of Parliament if they go against natural law on the Christian nation that England is, right? So Edward Coke, just let me have a quick drink. Are you all enjoying this, by the way? Don't forget, sharing is caring. The more you share, the more you care. And again, if anyone wants this document, the document is actually on the website as well. I've actually used parts of this in other cases, but just to make sure everyone's aware, Restore Britain or Restore England. Restore Britain needs to restore England to the common law, and the only way of doing that really is to separate Scotland from that. Southern Ireland is now under Roman law. It is completely under an administrative system of law, which is the European Union. Northern Ireland is still a common law jurisdiction. We need to offer complete independence to Northern Ireland, and they can vote on that, or they can stay with England. But Wales is still part of England. It's a common law jurisdiction. The two completely odd ones out, literally, are Scotland as a Roman law jurisdiction and the Republic of Ireland, right? and they are particularly problematic to England. So Sir Edward Coke is a renowned author of the 12-volume history of English law. His contributions to the development of the common law are said to be incalculable. Indeed, Coke has been called Shakespeare of the common law, and Sir William Holdsworth once wrote in the following about him: what Shakespeare has been to literature, what Bacon has been to philosophy, and what the translators of the authorized version of the Bible have been to religion, Coke has been to the public and private laws of England, according to his biographer Alan Boyer. And just to make sure you're aware, although I can't pull it off at this, otherwise my dragon might go pear-shaped. But these books here are actually the first part of the Institutes of the Laws of England, Coke, Volume 1. And as you can see where I've gone through that book, there's certain elements at this that I can pull straight up. For example, there are elements in here talking about the Magna Carta. There's other elements in these books. This one here, for example, Volume 1. The statute of the Magna Carta, though it be in form of charter, was being granted by assent and authority of Parliament. Little John here said it is a statute. The parliamentary charter have divers appellations in law, and then he goes into detail and he says it can never ever be removed. It is the liberties of the people of England, right? So everyone needs to understand that, and all of what I talk about comes directly from them books. And just to make sure everyone is finally aware of this, this is not a green screen, right? This is not a green screen. If you go to that one there, which I could pull out now, volume number 10, Halsbury Statutes, 4th edition, constitutional law, right? And then you get these knobs of barristers and judges who've never, ever, ever read foundational law of England, right? So you, as an audience tonight and today, are getting more of an education than the king has ever had, because all he's got wrapped around him are liars and frauds, right? So again, whenever the common law has been applied, Coke's influence has been monumental. He is the earliest judge whose decisions are still routinely cited by practicing lawyers. The jurisprudence to those writings one turns for a statement of what the common law held on any given topic. His discussion of a phrase from Magna Carta, nisi legem terrae, is one of the earliest commentaries to give a deeply constitutional renaissance to the phrase due process of law, right? So if you look at 1384, I think it was, the observance of due process, all of that come directly from the Magna Carta, and it's still law to this day. That's why I'm saying there's different sections, different laws on our constitution, a time immemorial, convention, all of that comes into English law. A deeply constitutional renaissance to the phrase due process of law for his defence of liberties and property rights, for his assertion of judicial independence, right, which we also know because Her Majesty the Queen, July 20th, 1988, made a declaration to both houses of Parliament where she expressed that the independence of our judiciary actually come from the English Bill of Rights, where it nailed it and said that the independence of the judiciary was part of that settlement. That meant that the king couldn't mess with them, and then they put the power back in our hands, which is why we have to create a formal address. And the only way you're going to do that is to elect members of Parliament that actually represent us, the people of England. You won't get that when everyone in there is British or Scottish, Welsh or Irish, right? Because there is not a single Englishman in that House of Parliament, right? Or the Lords. To the phrase due process of laws, for his defence of liberties, active, careful role in adjusting laws to demands of litigants and the interests of society, few figures have deserved more honour. No, I agree. And again, there are two senior judges. One was the first president of the Supreme Court that actually described Coke as a fraud. Right, he just happened to be Jewish, meaning that the president of the Supreme Court described Coke as a fraud. Right. And I just want to make sure everyone understands this. The president of the Supreme Court was Jewish, right? If you went for English law, he would never have been a judge in this country. Our jurisprudential matters, Coke relied quite heavily on Christian philosophy to both defend and explain the common law. Coke believed that the true nature of law is to be always fair and reasonable. The basic test of reasonableness, he contended, lies in the ability of each and particular law to withstand the test of time. Indeed, his own description of the common law as the product of artificial reason implies that laws should be endowed with internal logic, coherence, structure, and proper functioning. What Coke meant by artificial reason is therefore the delicate combination of natural reason, which is inherent in the realization of the law, combined with the specific type of legal reasoning which has been developed across time by all learned lawyers. Right? None of these people that we've currently got as lawyers are learned lawyers. The nearest thing to a common lawyer, as this document describes, is someone like me. There ain't many people like me out there in this country. There is in America, and we can bring some of them in to give us assistance when we're going through the system to clear it out. History informs that Coke famously angered King James I by declaring that even the king himself ought to be under the God and the law. The argument was viewed as treasonable by the monarch, who claimed that he, as the king, personified the law. But Coke remained resolute, and he cited Lord Bracton to remind James that the king shall not be under man, but under God and the law. In sum, the same Christian principle expressed in the 13th century was evoked by Coke in order to govern the common law over 300 years later. This momentous encounter of Lord Coke with King James left unprecedented mark on the development of the common law and, more largely, on the development of the rule of law in the West, right? So also in America and various other countries. I just want to emphasize this to everyone who's listened to this. We do not have in English law something called desuetude. So Roman law is so shit, right? The way they compile it and make it is for there, then, and that's it. And then if it hasn't been used for 100 years, it's obsolete. The common law don't work like that. If you're going to make law under the common law, it has to have something, and it's integral to the common law, which is continuity, right? So when you talk to anyone who knows about the law, there is something called continuity of law. That is why when laws are made, and a precedent is set, it's very difficult to reverse it. It is very rare in the common law, if they're real common law judges, that a precedent that they set 150 years ago, which is why I referred back to a lot of the judgments in the election court hearing, right? They haven't been reversed. They're still there, right? But the final two judges was ignoring me, right? Because they're administrative law judges. They should never have heard that case. They were switched on us, right? We won the first two sets of cases. And that's what I'm trying to say to people. The English common law is the best type of law, and that is why England is under attack. The communists, the Marxists, and the Roman law groups of people, Sharia, all of them people, it is all a form of Roman law, Napoleonic law. And that type of law is completely alien to England. So again, what Coke meant by artificial reason, delicate combination of natural reason, which is inherent in the realization. Not sure if I've gone too far there. Coke declared, I'm not sure if I've lost where I was. This particular understanding to both defend and legitimise the common law made evident in numerous of his judicial rulings. In Calvin's case, which I've brought up before, 1608, for example, he argued that God's law to be inherent in human nature and so superior to the positive law. Positive law means man-made law. Man-made law. Positive law means parliamentary law. And as Chief Justice of the Court of the Common Pleas, Coke declared, the law of nature is that which God, at the time of creation of the nature of man, infused into his heart for his preservation and direction. And this is lex aeterna, the moral law, called also the law of nature and written with the finger of God in the heart of man. Now, if you go and read law or start studying law today, they will tell you there's no such thing as the moral law, right? Which is bullshit, right? So that's another reason why most law degrees today, they're administrative law only. Let me just, can you all see and hear me? And you're all quite happy? Yeah, go on, Alan. I thank you. Right. Let me just make sure I'm getting this right. Oh, let me see if I can pull this up. Is everyone seeing and hearing me? And you're okay with me carry on reading this out? I'm trying to see if there's anything that's come up on my screen as yet. Are you all right? 5v5, right? This is quite a heavy readout, really, because it takes time to read it all. You probably have to listen back to this 2 or 3 times. But I can tell you this is one of the best essays written by a law professor in Australia, and it actually goes really deep into it. And there's lots more, by the way, just to make sure everyone's got that. So again, the strong reliance on Coke on natural law principles was particularly manifested in Dr. Bonham's case of 1608. Another of his most celebrated, does everyone know what the other case was about, which was the Calvin case? The Calvin case was a case where we had 2 separate monarchs, and the monarchs come together as one monarch, right? But we didn't have the Acts of Union, right? The treaty and then the Acts of Union brought in as domestic law. So we was functioning as a single monarchy, but 2 separate nations, 2 separate jurisdictions, 2 separate countries. It was the best way of doing it, right? And that happened in 1603. Well, a situation happened with a Scot that was saying that he had the same rights as an Englishman in England, right? And it got took to the High Court. And he said, yeah, you share the same rights. It's the same monarch and the justice comes from the monarch and we are the judges of the monarch, then you share the rights. But vice versa. So if an Englishman is in Scotland, then you share those rights. And it went against us being tortured in France right the way up to 1708. But that's another side angle. Strong reliance on a natural law, particularly manifested in Dr. Bonham's case, 1608, another one of his most celebrating court rulings. There, Coke appeared to appeal to God's law even as a justification for the invalidation of parliamentary legislation, to elucidate why the London College of Physicians should not be entitled under an Act of Parliament to punish Mr. Bonham for having practiced medicine without a professional license, Coke stated, right? And there's more of that. Like in the book here that Simon Layson gave me, I've got the full case of that, and it's fantastic. Not just the basic case, the full case, and it's a really fascinating read. And it was put together by the Secular Society, and it appears in our books that many cases the common law will control acts of Parliament and sometimes adjudge them to be utterly void. For when an act of Parliament is against common right and reason, or repugnant, or impossible to be performed, the common law will control it and adjudge such act to be void. Right. So what they're currently doing is trying to destroy England with devolution and regionalisation, they're also destroying the rest of the British Isles, right? I'm not interested in Scotland. I am interested in Northern Ireland. I am interested in Wales because they're common law jurisdictions, right? None of them people voted for this, and they have got a common law. They've got access to the English common law, right? So therefore, Wales and Northern Ireland are with England. Scotland, we should put a big wall up and say, get on with it. And the same thing should happen with Southern Ireland and Northern Ireland. Put a big wall up. We'll have a tunnel right across the St. George's Channel that belongs to us in the first place anyway, and we'll tell everyone else to get on with it, right? And they will not get into England, right? So the view expressed by Coke regarding the judicial function is derived from his general impression about the institution's antiquity, its integrity in the civil polity, and it's responsible for the protection and supremacy of the rule of law. Being a judge himself, Coke thought that judges like him ought not to create laws, but rather to declare or enunciate the existing ones insofar as these laws are hidden and waiting to be discovered, so that the judicial function is essentially for him a matter of legal discovery, not making of law. According to Coke, legal change by the judiciary should serve no other end but that of revealing and clarifying the law. New adjudication, he added, does not make new law, but makes plain the old. Adjudication is the dictum of law, and by the adjudication law, which was before hidden, is newly revealed, right? So nothing on earth, there is nothing new on earth, right? And all will be revealed. The idea that the word is governed by invariable laws that dictate how societies ought to be governed and structured was an accepted principle in Coke's time. Indeed, all leading English jurists of the time shared with Coke the common belief in eternal laws that operate in as fixed a manner as the physical laws of nature. Their jurisprudential approach, as Professor Burnham explains, must be understood as an integral part of their total philosophy, including their religious philosophy and their philosophy of natural sciences. Hence, in the third report, Coke argued that the rule of law ultimately resides in God's wisdom as displayed through the creative handwork in nature. For as in nature we see the infinite distinction of things proceed from some unity, as many flowers from one root, many rivers from one fountain, many arteries in the body of man from one heart, many veins from one liver, and many sinews from the brain. So without question, lex orta est cum mente divina, and this admirable unity and consent in such diversity of things proceeds only from God, the fountain and founder of all good laws and the Constitution. John Selden, 1584 to 1640. Tell me when you've had enough of this, people. There's about another 6 or 7 pages of that. So Matthew Hall, let me have a look. There's still loads to do on this. Do you think I should carry on with that tomorrow evening? Do you want me to carry on where I left off and we'll do a 2-parter, or do you want me to carry on? I don't mind. John Selden worked very closely with Coke in the draft of the 1628 Petition of Right. For such, remember I said we got a Petition of Right, separate law, right? And then part of that is codified. But one of the reasons why there's no taxation without representation, why you can't put billet soldiers in your house is because of that whole legal period. Kicked out of the planet. Let's have a look. Tax is illegal. Let me have a look. Andy, 5B5. All good. DD, you're proper smashing it up tonight. I'll carry on reading this because, again, The names and the people that I'm talking about here are all the people that I've got their books on my shelf, right? And I really don't understand when you try and talk to a barrister like that, Stephen Barrett, who is gay, right? And then I think I watched something today with Robin Tilbrook, and he mentioned that there's some new vicar of some church, and he just happens to be a gay man, and then starts wrongly telling people what the Bible says about gay men. And you think, how did we allow it to become this corrupt, right? It's fairly obvious it's not a good thing. John Selden worked very closely with Coke in the draft of the 1628 Petition of Right. For such participation, they were both put into prison in the Tower of London. The petition, so don't forget, Coke and John Selden. So the Selden Society that I talk about is basically the Selden Society, an extension of what he is. It's a bit like having the Coke Society, right? Although I can see that the Coke Society might, in today's day and age, might call in the wrong type of people. But for such participation, they were both put into prison in the Tower of London. The Petition of Right, a declaration of Parliament in the run-up to the English Civil War, set out the basic liberties of the English subject that even the king himself as monarch was prohibited from legally infringing. Right? Remember what's happening with this king at the moment and what he's done. It is completely unlawful. I can bring something else up on the screen if you want now, and I will read out what Parliament said, that this and it was some years ago when they said the king couldn't have anything to do with Islam. He would in effect abdicate by doing that, right? English civil set the basic liberties and English subject and the king himself, and yet he did not deny but rather affirmed the existence of natural law, and in condition as the main source of legality. On the more practical side, however, Selden was particularly interested in stressing the contractual nature of legal obligations. Think about the monarch's oath and the role and the declaration of the Declaration of Rights. They couldn't have become king and queen unless they agreed to its terms, and they bound their future generation of monarchs to them terms. That's what the coronation oath was all about, right? And the role conscious in fulfilling such obligations. His most distinctive contribution to the common law was the interpretation of the contractual character of moral obligations generally. It is not only a breach of prohibition that is offensive to God and punishable by him, but also the breach of covenant. Indeed, for Selden, the most important rule of natural law appears to have been the rule that contracts are to be kept, pacta sunt servanda, which he applied not only to divine contracts, but also to human contracts generally, right? And that's where an Englishman, his word, because when an Englishman gives his word, it is his bond, right? You can just shake hands with an Englishman and it's a deal, right? And the deal's done. It's about honour and about right. And you won't go back on that. As long as both sides keep to the contract, there's not an issue. You can do things on an handshake, right? And that was because we were Christian in nature. And if you go back to prior to all of this, even what I'm talking about now, we had an oath-based system, right? And you was an oath taker. Well, if you went against your oath, they would cut your tongue out, right? Sir Matthew Howe, again, I've got the book over there from Sir Matthew Howe. Lord Coke also exercised a great influence on the jurisprudential work of Sir Matthew Howe. His History of the Common Law, top left. No, keep going, that's it. How do I know these books? Right, so there it is there, right? My wonderful assistant has just passed that to me. The History and Analysis of the Common Law of England, Sir Matthew Howe, right? Again, that book's there. His History of the Common Law provided the first comprehensive portrayal of the history, origin and growth of the common law. And Howe's book remained the standard book on early English legal history until the late 19th century. It is a book said to epitomise the philosophy which dominated English legal thought in the late 17th, 18th and early 19th centuries, and as such it still plays an important part in the intellectual outlook of many English and American practicing lawyers and judges, certainly me, right? I can't see many judges over here even knowing who the geezer is, to be honest. Howe was not just a legal historian, but the writer of numerous tracts in the fields of mathematics, another mathematician, right? Lord Denning was a mathematician. Natural science, philosophy and theology, pioneered by him and commemorated a century later by Blackstone. The modern method of the common law bears a remarkable resemblance to scientific mythology. He was greatly influenced by his knowledge of the exact and natural sciences, on which he wrote several long tracts. He was well acquainted with Boyle and Newton and with some of the founders of the Royal Society of London. Such devotion to the systematic study of the natural sciences and theology led him to accept not only universal values, but also the distinct body of natural laws, universally binding on every society. Accordingly, criminal offences such as homicide, rape, and theft were deemed by him eternal violations of the natural law, even if no positive law was prescribed against them, right? And it was often said that you don't have to tell someone in England that murder is against the law. Everyone knew it naturally, right? It was natural law. It was the common law. It was a common law offence. That's where common law offences come from. It doesn't have to be positive law. It doesn't have to be written as a law form from a parliament. The common law created because it was against God's law, right? Against them. Naturally, Howe fully acknowledged that the level and degree of punishment to be applied for any such crimes had to be determined by positive laws. These must be left, for the most part, if not altogether, to the positive law of each particular state. And yet, Howe also comments that, so far as possible, these positive laws pertaining to criminal sanction must be studied and analysed according to their historical evolution. Burnham summarises Howe's jurisprudence. The divine law is found in those biblical precepts that are intended to have universal application, such as the Ten Commandments. Natural law includes such divine law, as well as other legal principles and institutions that are in fact common to all nations. Divine law and natural law are binding on all rulers. Positive law is distinct from natural law in that it is subject to the discretion of the lawgiver. Although the wise lawgiver will act according to reason and will do what is socially useful under the historical circumstances. All right. So the historical circumstances of the Coronation Oath Act, right, and what it means and where it come from, and the Declaration of Rights is all important to what the King is doing today, right? So William Blackstone, 1723-1780, the natural law foundation of the common law is said to have received its full exposition through the influential work of Sir William Blackstone. Blackstone delivered the first series of lectures on the common law ever presented at the English University at Oxford in 1753. His commentaries on the laws of England 1765 to 1768 is broadly perceived as the most celebrated law book in the English language and praised by many as the first accessible, authoritative and comprehensive guide to the complexities of the common law. Thomas Jefferson described its lucid in arrangement, correct in its manner, classical in its style, and rightfully taken its place in the side of Justinian's institutes. Blackstone was a committed advocate of material and moral improvement. He saw himself as a sort of common law's Newton, transforming darkness into light. Hence, Blackstone employed the language of Newtonian physics to describe the function of England's legal political institutions. For Blackstone, the king, the lords, spiritual and temporal, and the Houses of Commons formed a mutual check on each other, like the separation of powers, right? Like three distinct powers in mechanics. They jointly impel the machine of government in direction different from what either acting it by itself would have done, but at the same time in direction partaken each and formed out of all. Newtonian science also inspired Blackstone to formulate his famous definition of the nature of the laws in general. And this is a quote. Law, in its most general and comprehensive sense, signifies a rule of action and is applied indiscriminately to all kinds of action, whether animate or inanimate, rational or irrational. Thus, we say the laws of motion, of gravitation, of optics, of mechanics, as well as the laws of nature and of nations. And it is the rule of action which is prescribed by some superior and which the inferior is bound to obey. Thus, when the Supreme Being formed the universe and created a matter out of nothing, he impressed certain principles upon the matter from which it can never depart and without which it would cease to be. When he put the matter into motion, he established certain laws of motion to which all movable bodies must conform, and to descend from the greatest operations to the smallest. When a workman forms a clock or other piece of mechanism, he establishes at his own pleasure certain arbitrary laws for its direction, as that the hand shall describe a given space in a given time, to which laws, as long as the work conforms, so long as it continues in perfection and answers the end of its formation. In commentaries, Blackstone contends that the common law is founded on the basis of both the natural and the revealed law. On these two foundations, the law of nature and the law of revelation depends on human laws. That is to say, no human law should be suffered to contradict these. In this context, Blackstone, the great advocate of parliamentary sovereignty, writes favourably about the natural law being always superior to the positive law. Natural law being coeval and mankind and dictated by God himself is of course superior in obligation to all other. It is binding over all of the globe, in all countries and at all times. No human laws are of any validity. If contrary to this, and such of them are valid, derive from their force, and all their authority mediately or immediately from this original, which is why we don't do communism or fascism or authoritarian government, right? Blackstone's statement that the natural law is dictated by God himself echoed the sentiments of his predecessors. His definition of the natural law as conveyed in the commentaries, the most revered and influential legal text in America during the 18th and 19th centuries, was heavily relied upon when adapting the English common law example to the American situation. Blackstone's portrayal of the natural law as connected to God, derived from the nature of all things created by God, basically reveals the philosophical foundations of American constitutionalism. Indeed, the whole understanding of natural law by the American founding fathers virtually echoes Blackstone's own understanding of the subject, as Wilfred Prest points out. Blackstone's clearly stated emphasis on the authority of the law of nature and the absolute rights of individuals was of particular importance in formulating and defending the case for armed resistance to King George and his Parliament. The commentaries thus became and remained the basis of US legal education, moulding American legal thought and practice throughout the 19th century and beyond. According to Albert Alsquer, Blackstone taught American revolutionaries their rights, helped inspire the Declaration of Independence, influenced the deliberations of the Constitutional Convention, articulated a sense of providence like one that touched Abraham Lincoln, and instructed the children, grandchildren, and great-great-grandchildren of his initial American readers on the virtues of the English common law. The acceptance of natural law was then mirrored in the American judiciary, with many judges placing reliance on Blackstone's definition when adjudicating legal matters during the 19th century. Within this historical context, the concept of natural law was openly acknowledged and advocated by Joseph Story, the first named professor of law at Harvard University and Associate Justice of the United States Supreme Court, who linked natural law to the rights of conscience, which are given by God and cannot be encroached upon by human authority without the criminal disobedience of the precepts of natural as well as revealed religion. Why does it matter? As it can be seen, the English common law was largely inspired by Christian ideals, with the moral conviction of judges and legislators resulting in enduring legal principles. The English common law was the basis of the legal and political structures in both Australia and the United States. Above all, Christianity was viewed as the fundamental part of English law at the times the English settled the first US and then Australia. As such, the leading early settlers and founders of these younger nations embraced this religious heritage, as we shall see. And while the Australian legal system cannot lay claim to the historical depth of America and England, it too was built on solid foundations derived from Christian philosophy. These foundations were largely inherited through the country's reception of the English common law, in addition to the adoption of the American system of federalism. We're Confederate. The fundamental values of the English legal tradition were exemplified and formulated by Christianity, not only as a theory, but as a way of life and feeling, as a religion. In short, the religious identity resulted in an inevitable political environment whereby the citizens could take their legal rights seriously. For instance, by considering these rights God-given and not government-created, they would also find the law-abiding nature of Christianity a justification for respecting principles and institutions of the rule of law, and primarily as a matter of higher moral obligation. Although the most significant common law principles are drawn from the principles of Christianity, during the second half of the 19th century, a considerable shift occurred. Judges and lawyers came to regard the Christian foundations of the common law as no longer relevant. As the judicial elite began to accept the belief that humans have evolved through a natural process of adaptation and change, they then automatically assumed that society's moral standards and codes and behaviour might undergo an evolutionary process as well. Of course, when the tenets of evolutionary theory are applied to matters of justice and legality, then the biblical foundations of the common law are eroded and undermined, meaning, therefore, that the moral basis of the common law as a system of judicial precedents ceases to rely on objective standards that are objective and universal, so as to embrace instead the subjectivity and contingency of personal opinions of judges and lawmakers. Charles Colson and Nancy Pearcey explained the idea of that human or positive law must reflect a higher law was seriously challenged in the latter part of the 19th century, especially after the work of Charles Darwin and his theory on evolution. That there is no created moral order that functions that basis for the law. And then he goes on to say a bit more. I don't want to keep going into that, but the conclusion is there. There's only a couple more paragraphs, but he basically just gives his opinion of what's going on there. Let me stop sharing and go back to this. The reason why is because I don't want to keep pushing forward and pushing forward and pushing forward, right? You understand the gist of this, that the common law. And again, if anyone wants a copy of that document, let us know, and you can read through it at your leisure. And let me have a look through this. Any questions coming up? For Hawk, Raymore, question DD. Did Princess Anne become royal regent a week or so ago? If so, Chuck has passed the Red Book to his sister. I don't know. I haven't heard anything to do with that. Oh, right, okay. If you've got that on there, I'll send that out again. Copy. So if anyone wants a copy of that directly, it's on the Daddy Dragon website. I'll put that out there so anyone can go and pick that up. English Constitution, reference to regions. Do you think the dismantlement of national service 60 years ago has hampered the TE ability to form militias in county shires to find enough fighting men? That is a good question. The reason why the TA was brought in was to hoover. What they've done, they've disbanded about 300 English regiments. There was lots of English regiments. They've disbanded them, and the militias were still operating up until the Second World War. And what they've done is they've brought in the TA to bring it under the auspice of the Parliament and the government, right? But the militias were not associated with the government. The militias were the people, right? And there's often things that are wrongly said, especially with what they've said with reference to what was it they said? It's completely tripped my mind. Paramilitaries. Often it is described that militias in Northern Ireland, and they were militias, were paramilitaries. That is not a paramilitary. Paramilitaries are the police. So a paramilitary is our current police force. It is in effect a standing army against the people. And militias, and why they disarmed us, and by the way, it was the police that disarmed us, right? It was chief constables that disarmed us. And there's a case and a reference to that I've got that I'll hope you be using in a court case shortly, because they actually breached their oath by doing that. But there's a proper argument to be had. So, do I think the TA hampered? Do I think there's enough fighting men here? I do think there's enough fighting men. But people going to the pub and having a beer and thinking, I'm being honest with you, my personal opinion is not going to be able to vote your way out of this, right? There has to be a strategy of what we're doing. And part of that strategy, and I am putting my cards on the table here, I think Restore England needs to go full kill, and a few of them need to go out to the White House. You need to prove that you're serious, right? And part of being serious is to take back each county or shire of England. They've started on that process, in my opinion, with Norfolk. By coming away from that, trying to go into the red wall, that's completely corrupt, right? You can't beat professional fraudsters when you won't even listen to what the fraud is, right? And they all think they're all cocky and young and know what they're doing. Rupert Lowe, not being disrespectful, I've got to be honest with you, I think he's a bit naive. If he thinks that these people are just going to handpack power, you've got to think again, right? There was a reason why they disarmed us. They knew that they was going to do something that we'd shoot them for, right? That's the reality, right? So I just want to make sure you understand that. Hopefully I've answered that question. I personally believe there are people that will fight, right? I will fight for my country. I haven't left this country. There were and still is a number of situations where I could leave this country, but I will not leave this country. And I'm certainly not one of these people, particularly sitting in Spain, giving it large, right? And pulled all their family out and then want to wind the situation up and then start talking about civil war, right? Forget the civil war elements of this. There isn't a civil war, right? It's a defensive war and we need weapons. You may have to go to the link and get the HWD bit doesn't always work in Rumble chat. I don't know what that means. Someone else should just put saying, I wish Jim would put stuff in there when I'm doing a show that he actually wants me to show. Thanks for another extremely interesting show. I'll watch the remainder tomorrow morning while having breakfast. Good night. Dave, no worries. Be lucky. And good night to Mook. Let me have a look. Jason Graham, the US Supreme Court is taking up the case against using a 6-person jury in place of 12 for non-capital crimes in Florida. And hopefully they will strike that down. You should always, once you let them start on any process to do with their jury system, right? That's what happened over here. They targeted the grand juries first. Now we ain't got grand juries. Then they started coming back and saying we'll accept a majority verdict, which is all wrong, right? There's either doubt or there isn't. If one person comes back with doubt, then it's a not guilty. And then they changed it because of the Stephen Lawrence case, where they then started bringing back double jeopardy, right? Again, we dealt with all this stuff. It's foreigners that are attacking our system. If you don't like it, go somewhere else. Obviously, talking about the foreigners. Right, I'm now looking directly at the chat. Thank you to everyone that has tuned in. I know it was a bit of a marathon of a readout, but I've also shown you earlier on in the show where the actual trial come from. Some really interesting parts if people want to read a trial. Literally, it is verbatim what was said by the judges, what was said by the defendant. And again, all that information is there. All you got to do is go and look it up. I've sent out the links. That's it. I'm going to say good night, God bless. I'm going to say, don't forget what I believe in. The Constitution is the solution. If you want me to do a seminar, don't forget to get in touch with us. All the links are out there. Don't forget, Restore England. All I'm trying to do is advise you. Don't trust these lawyers. Don't trust these solicitors. You need to understand what the Constitution of England is, right? We are being systematically destroyed by Marxists and communists and fascists, and we can take it back, but you need to know the Constitution. No one in the world will hold it against us. Our biggest ally is the United States of America. They are the people of England and trust us with firearms, right? We don't need their boots on the ground, right? But what we need is to be rearmed, and then we take down this structure that they put in place. And literally kick them all out. That's it. So again, I'll say it one more time. The Constitution is the solution. If you want me on UK Column, don't forget to contact them. That video today, go on there. Just say, Brian, why don't you have Graham on there, right? And he'll give you an education on the English Constitution. I could even bring it up on his show and say, listen, tell me what it is, right? The new build house for illegals will end up getting burned down. People that are angry now. Again, whatever we do needs to be structured. It needs to be organised. And we need to start organising properly. The problem we've got is the state has so much power over us. Literally, so much power. You got to take it back. That's it. I'm off. Tilly poo. Good night. God bless. Au revoir. I am going to hit the button. Bye.